Please get ready for a dictation of exercise number 1 from legal material, which is suitable for any court skill examination. 5 seconds. Start. This appeal is directed against the judgment of the Additional Sessions Judge dated 6 February 1997 in Sessions case number 29 by 1996 Police Station Dabri, holding the appellant guilty of the offence of murder of Miss Malka, punishable under section 302 of the Indian Penal Code, and also the consequent order on sentence dated 7th February 1997, by which the appellant was sentenced to undergo rigorous imprisonment for life and also to pay a fine of rupees 1,000, and in default of payment of fine to undergo rigorous imprisonment for a further period of 6 months with benefit of section 428 of the Code of Criminal Procedure. Briefly stated, case of the prosecution is that Miss Malka, hereinafter called the deceased, was married to the appellant and they were living at Palam Colony, New Delhi. It is alleged that on the evening of 9th January 1994, at the above referred house, the appellant and the co-accused Rajkumari, who could not be arrested during investigation, in furtherance of their common intention, committed murder of the deceased by pouring kerosene over her and setting her ablaze. The information about the said incident was conveyed to Palam Colony Police Station, wide DD number 35. We may note that in the said DD report, it was mentioned that someone had informed that a tenant of Palam Colony has set herself afire after pouring kerosene on her person, and her condition was quite serious. A copy of the DD report was handed over to the ASI VP Singh for verification, and he left for the spot of occurrence along with Constable Bhoop Singh, where he found that the injured Miss Malka had been removed to the hospital by her husband. On this, he contacted Police Post Palam Colony. By that time, the injured had already been admitted in Safdarjung Hospital, and intimation in that regard was conveyed to the Police Post Palam Colony by the duty constable posted at Safdarjung Hospital, which information was recorded as DD number 45. Sub-Inspector Ved Singh instructed PW8 to stay at the spot of incident and told that he was going to the hospital. Sub-Inspector Ved Singh, on reaching Safdarjung Hospital, obtained the MLC of the deceased Miss Malka, on which Dr. Pradeep Tandon had recorded the history as given by the patient of sustaining the burn injuries when her husband and sister-in-law had caught hold of her and poured kerosene over her and set her on fire. The patient was declared fit for statement by Dr. Das, and Sub-Inspector Ved Singh recorded her statement, wherein she disclosed that her Jethani, Rajkumari, wife of the elder brother of the appellant, and her husband were responsible for her plight. She disclosed that kerosene oil was poured on her by her Jethani, whereas she was set ablaze by the appellant. Since the statement given by the deceased disclosed the commission of a cognizable offence, Ved Singh appended his endorsement to the said statement and sent it to the police station for registration of the case through Constable Jairam at 10:25 p.m. On the basis of the said statement, which was also attested by Dr. Ram Chandar, a formal FIR was recorded at the police station at 11:10 p.m. and a DD report number 33A was also recorded regarding the registration of the FIR at the police station. Appellant has been convicted under section 376 of the Indian Penal Code by the learned trial court and sentenced to undergo rigorous imprisonment for 7 years with fine of rupees 10,000 and in default of payment of fine to undergo simple imprisonment for 3 months. Stop.